His first Facebook live streaming question and answer show. My name is Andrew Feldstein, the principal of Feldstein Family Law Group. We're a GTA family law practice where we practice exclusively in family law out of our 4 offices in Markham, Mississauga, Vaughan, and Oakville. Today, joining us is Western Law professor Claire Houston. She teaches family law at Western University and has completed research on several family law topics. She is also the 2021 recipient of the Dean's Research Fellowship for her project on spousal support for men. Welcome to the show.
Thanks so much for having me, Andrew.
So I guess my first question that I'm thinking about is, what made you pick this topic as a research topic?
That's a great question. So I'd read some commentary and seen some cases where there were allegations of potential gender bias in cases involving claims by men. And I wanted to explore that a little bit further. I was also really interested in the topic because it represents a bit of a shift from what we've been seeing up until this point in family law, where the majority of claimants are women and their claims tend to look one way, or at least a predictable kind of way. And so I wanted to see what the claims looked like when they were being made by the other side, so to speak.
And I'll start by jumping to the end, and then we'll talk how you got to the end. But what was your conclusion?
So I made a number of conclusions, some of which I was not expecting to come to. On the issue of gender bias, I think that it's potentially more complicated than what commentators and also litigants were suspecting. So one of the claims was that men were not very successful in receiving awards, tended to receive smaller awards and also shorter awards. And I think that there is some truth to that, but I think that there's also some reason to be concerned on the part of female payors also. So I thought that both men and women tend to have the ability to be disadvantaged in these cases in very different ways.
Well, I found a few interesting things you say there, and I'm going to try and work through them. I'm going to start with one where you say shorter awards and less amount, because we haven't spoken really before the show. And anecdotally, that's exactly what I've seen happen, where if I had a case and I was representing the wife and I thought it would be, and for our viewers who are familiar with the spousal support advisory guidelines, it generates a low, a mid, and a high range, and it generates a low duration to a high duration, which may or may not be indefinite. And in my experience, when I've represented the male payor, the support is typically low to mid, where if I was representing the female payor, it was mid to high, and the duration would be on the lower end and quicker to get a termination date. And I don't know if that's what you're saying. You're seeing more along the lines than the male support payors.
Yeah, so let me maybe address a couple of points there. So what I did for the study, just to give people some context, is I looked at all reported decisions that were decided between 2010 and 2020 that involved claims by men for spousal support. And I found, using Westlaw, 363 cases. And so I looked at how often men were successful, what types of claims were successful, and got a little bit of information from that data set, so to speak. I should say a caveat here, which is that reported decisions cannot tell us everything about what's happening in a particular space. Reported decisions are just the tip of the iceberg, so to speak. Not every decision is reported, and a lot of decisions don't actually end up with a decision because they don't get that far along in the process. But what I did find was that in the reported decisions, men were successful about half the time. So about 50% of claims resulted in a spousal support award. I don't have comparable data for awards for women, so it's hard for me to say, other than anecdotally, whether or not this is a low rate of success or a high rate of success. But there were a couple things in that finding that I think are really noteworthy. One is that the majority of claims that are made by men are for mixed entitlement awards, or at least the basis is a mixed entitlement basis. So men are saying, I'm entitled to spousal support for both compensatory and non-compensatory reasons, right? So compensatory reasons as well as need. And while the majority of these claims are mixed, most of the actual awards are needs-based. And I thought this was really interesting because it sort of suggests to me that men are having a harder time making compensatory claims than they are making need-based awards. Um, and the other sort of interesting component is that in a lot of the cases where support was rejected, the judge had imputed income to the male claimant. So I think there's also a possibility here that the numbers, at least that are presented, are different from the numbers that the judge is using to determine whether or not there actually is a basis for support. So in terms of your question around amount of award and duration of award, if these awards are predominantly needs-based, they're typically going to be smaller and shorter than compensatory awards. So that can kind of help to explain why that might be happening. But also in terms of success, and again, amount and duration, it might have to do with the amount of money that a court is assuming a man has access to when determining how much the support award should be for.
So there's a few takeaways that I'm hearing from it. And I find it interesting what you're saying about the compensatory versus needs-based claim. And for our viewers to understand, the word compensatory really describes it. And I like to give the simplest example. When someone stays home and doesn't work for 15, 20 years to help raise the family, there's a clear compensatory claim versus saying the custom standard of living's been reduced and I need some money because I can't make my budget or my reasonable budget, and that's more needs-based. That's really a simplistic way of describing it. Now, when I go through what you're saying, I'm mindful of, I'll never forget, this is probably about 15 years ago, I was at a continuing legal education course, and usually the last panel is a panel of judges, and this was actually one on spousal support. What the questionnaire was based on two final scenarios. One was, it was a wife that was a lawyer and hadn't worked in 15 years, and whether she would be imputed income. And in every one of the cases, the judges said, oh, no, she's been out of the practice of law for 15 years. We're not going to impute her with anything beyond minimum wage. And then it got to a man, and it was a man who hadn't worked as as a medical doctor in 10 years. And he was the claimant for spousal support. And every one of them, until they got to the last judge on the panel, said, absolutely, you should get back to work. Absolutely, they're going to impute him income as a medical doctor. They had no issue with that. And then the last one looked at it, was about to talk, and he got a grin on his face and realized exactly what the people who had devised the questions had done. They gave two similar but different fact patterns to see the reaction of the court. And to a judge, the level of imputation in their minds was very different. And I thought about it and said, in my mind, it would be much easier to argue I was a medical doctor, but I owe this duty to my patients, and I was too stressed. I couldn't handle it. I couldn't do it, and I couldn't take the responsibility of it, and I got out of it. Versus I've always thought of a lawyer who's been out for 15 years. Go knock on some lawyer's door and say, I'll work for a year for minimum wage, and then let's talk. And they'll probably get back in and start to rise. So none of that was discussed. None of that was thought. But it goes exactly to what you're saying, which is when it came to the male recipients who are making the claims. Now, I don't know if they're just imputing to minimum wage or they were going to a much higher than minimum wage, but that's exactly what was going on that panel of, and I think it was 4 or 5 well-known family court judges at the time. So it's interesting that seems to be reflecting what your study said.
Right. I mean, it's not possible to draw any sort of firm conclusions, but I think that what we want to be concerned about is this assumption that men should be working, right? That they should be working more, an assumption that may not get applied to women in the same way. But, the flip side of that, and I think this speaks to men not having as much success in the compensatory realm. So I think that there may also be a hesitation to see men's domestic labor as being as valuable as women's domestic labor, especially when it comes to child rearing. So there were a couple of decisions from the sample where a court said the man was already unemployed and therefore did not have a compensatory claim for looking after the children, for example, because he hadn't been financially disadvantaged by doing that. And what that misses, of course, is the financial advantage that that childcare confers on the woman who's then able to go out into the labor force and improve her earning capacity and get promotions, et cetera, because of the work that's being done at home. So I think those are sort of the concerns that we would have coming out of the data. And I think they're really important to talk about.
I think that's fascinating comment because I picture myself in court trying to make that argument if the genders were reversed, and I don't even think those words would come out of my mouth for the various reasons that you just said, and how quickly I'd be shot down. Now, interestingly enough, I remember the first time I ever argued for a spousal support, a male spousal support recipient. I was probably around 2000, I'm guessing, I may be off. And I stood up, and my first argument to come out of my mouth, because he had been home for 15, 20 years raising the kids, was, Your Honor, the only reason I'm arguing entitlement and not quantum is because I happen to be representing the man. And the judge's first comment was, I'm already there, Mr. Feldstein, move on. So that particular judge was already there. Entitlement was clearly established, and it wasn't about that. It was more about what was the right quantum. So I was impressed by that in terms of that one particular judge. And like you say, that doesn't make for all the research, but I find it interesting that what I'm hearing and seeing anecdotally seems to mirror some of the things you're saying that you've noticed in the research. I do note that you said earlier that there's a problem or a concern for female payors, and I'm wondering what that was.
Right. So there were a couple other findings that sort of pushed in the opposite direction in terms of being a little bit concerned about gender bias against women. And so there's 2 points that I want to make here. One is again around domestic labor, and the other is around claims of intimate partner violence. So first, what I found in the sample is that many of the men who were making compensatory claims did not look like your typical housewife. So they were not house husbands in the sense that you might assume a housewife would be. They may not have been earning as much as the female, but the women in these cases were still doing a lot of the domestic labor. So the women were working, they were the breadwinners. The men were therefore in need when the relationship broke down. But we had the situation where during the relationship, the woman was actually doing more domestic labor than her partner. And this tracks what we know about heterosexual relationships and domestic labor burdens, especially when children are introduced into the picture. And so then you end up in a scenario where a man is claiming needs-based support from his wife, and the wife is in a situation where she may not feel as if she can claim any compensation for the domestic labor that she has performed herself. So, for example, it'd be difficult and potentially not very sympathetic if she were to claim spousal support from her partner who makes less than her, right, on the basis that she had performed this domestic labor. So she could argue that he had been economically advantaged by her domestic labor, but that doesn't seem right if he doesn't have the same resources that she does. And it's also difficult to argue that she's been economically disadvantaged, right? This is a situation where a woman has been doing a lot of domestic labor, but managing to become financially successful as a result. So what happens then is that that domestic labor sort of disappears from the calculus, from the equation. If you have a needs-based award granted to the man, the work that the woman has done in the home is to some degree obfuscated. It becomes a little bit ignored, so to speak. And this is interesting because this was one of the reasons, or at least one of the modern reasons, why spousal support made sense, was that we were trying to compensate women for labor that they were doing in the home. And so we have in these cases the potential to not be compensating women. And so the second point that I want to make is around intimate partner violence. And I was really surprised actually to find in the cases, again, the 363 cases, that about 20% of them involved allegations against the male claimant. And in about half of those decisions, support was ordered. So you had a situation where the male claimant was accused of being violent, and he then was also asking for support from the wife who was alleging that she had been abused. And in some cases, judges found that there actually had been violence, but found that their hands were tied and had to make the spousal support awards because of our decision to not consider fault in spousal support awards. So we have situations in which women are paying abusive men spousal support because the men have fewer economic resources than the women.
Okay, so that leads me into a few different areas that I'm hoping we can discuss. So I'm going to start off first with the domestic labor comment and the lack of ability for the female spouse to be compensated for their domestic labor. Uh, I think if you even were somehow able to establish entitlement, which I'm not convinced you would, you then go to the Spousal Support advisory guidelines, and without actually doing the calculations, we both know it's going to be low zero, mid zero, high zero.
Yes.
There's never going to be any spousal support in that. And I find, and again, I mean, I haven't done research, but when I have my clients who are the female payors, and it's obvious that they're going to be a payor, they hate it. They react very negatively. And the usual first comments that I get are, you mean I go to work, I make most of the money, I did most of the domestic labor, and now I have to pay that lazy SOB spousal support on top of it?
Right.
And I say, yeah, pretty much. When I have male clients with that kind of financial disparity, usually their question is how much?
Right.
They're accepting the concept that they're paying. I get what you're saying about the study that most women, or I guess in heterosexual relationships, it's usually women who do most of the domestic labor or greater bulk of the domestic labor. But in these situations, I haven't read all the cases you have. I imagine there may have been conflicting evidence on that point where the man is saying, no, I did most of the domestic labor, and she's saying, no, I did it. So there's conflicting evidence. I have no clue how court came down on it, whether they cared that much about it or not. And maybe that's an element of the compensatory claim as well. But common sense says there's a certain part of the daycare that if one person's at work, they may not, depending on their schedule, may not be able to pick up the child from school. They may not be able to drop the child off from school. They're not there to pick up the child on the sick days and take them to the doctor and dentist appointments. Even if they are doing the bulk of the cooking and cleaning, there are those things that are giving them the ability, as you said, to prosper at work. So to me at least, it creates a very interesting dynamic in that scenario. And then I think of the second piece that you're talking about with intimate partner violence. And I think of when I've had cases where there has been intimate partner violence perpetrated by the support recipient. And I can think of some cases where I've done that and it's been pretty clear. I often say to my clients, judges are people, and what they start with is that they want to do what's right. And it's our job as lawyers, and in a sense, what we are is a salesperson who is trying to sell your story and make the law fit to get you the best reward at the end of the day. And if I don't have a good story to sell, even if the judge feels tied to give support, the judge is going to have enough there probably to try and play with the compensatory claim, play with the duration, and play with the quantum, which may be part of where it's leading to, especially in the cases where they're saying, yes, there's entitlement. Like I have one case in mind where my guy's optically, he was a disaster. He was a nightmare. There were stalking allegations, all sorts of really nasty things. And his former spouse was a very successful business lady, and he had a decent income. And you could, I mean, we never went to a motion on it, and we resolved the issue at least temporarily at a case conference or settlement conference. And at the end of the day, a big part of what didn't move the needle were the optics of him. Just he didn't make for a sympathetic guy. And that's one of the things that I think you're getting at. And a lot of lawyers, I think it's younger lawyers usually don't appreciate that facts where they may not matter still matter for how you're telling the story, because courts don't like to see somebody who was abused or taken advantage of in a way that doesn't fit their narrative. And this kind of case to award an abusive partner all sorts of spousal support isn't going to make them happy. And they're going to want to reduce it where they can. And that's in the back of their head. So establishing that, I think, is helpful. And they probably also are recognizing, too, that if you leave that person in too bad of a situation, you're also increasing the probability of him ignoring whatever restraining orders out there. Because if you make somebody desperate, they may react desperately. So it's also important to, I think, for a court to balance that we don't want to be the one who wakes up one morning and read in the newspaper that this guy was at her home and killed her. Because that's I think part of the risk that you're balancing if you end up punishing somebody too much from that perspective and not be mindful of giving them some ability to live.
Sure. I think it's also maybe important to note that in some of these cases, it might be a reason to get your back up if you are counsel and you have a situation where there are claims by an abusive or potentially abusive spouse. You might want to be thinking about it as a tactic of litigation abuse also. There were some cases where it was pretty clear that the claimant would not be entitled to support, but had raised the claim probably to throw a wrench into the wheels and make things more complicated and potentially to sort of threaten the female. So I think that's one thing to maybe be thinking about also in these cases is the claim itself genuine, and if not, sort of how to then resolve that.
And I guess your data didn't necessarily look at claims that were genuine versus ones that were pretty obvious. Because in my business, the one thing you don't want to do when you go to court all the time for our viewers is take positions that are really stupid.
Yeah.
Because a judge is going to look at me and say, Mr. Feldstein, you know better. What are you doing here with this claim? And because they've seen me in court many times before and they know I know better. And when you get that commentary, it's A, somewhat embarrassing to your reputation, but B, I try to be very clear with clients. Don't spend your money on losers. And I get the concept in the early days, you may want to tick off the box for spousal support, and it may make sense at the early days to tick it off. But when you're sitting there at a settlement conference and you're trying to roll up your sleeves or settle a case, or you're going to, especially if you're going to trial where a judge is going to make a ruling, don't make claims that are complete losers, because when you do that, I'm saying this for any lawyers watching as well, or self-reps, if you're making claims that are complete losers, you end up having a judge perhaps hear the good claims as noise that they're not going to focus on because you've wasted too much of their time on things that they view as ridiculous, and now they don't like you. It gets back to you're selling a story. Focus on the strengths of your story, admit your weaknesses, but don't make claims that are outlandish, because if you make outlandish claims, that's where you're more likely to get knocked down. I remember one time as a junior lawyer, I made a claim for what I knew was an aggressive number, and the judge, who I'd been in front of many times, chopped me down a lot more, and it was a good lesson. It's come in, ask for a reasonable number. Don't come in asking for an unreasonable number, because where they end up from a reasonable number is going to be much better than where they end up from an unreasonable number. So I get what you're saying when you say some of these claims were probably just tactical and not realistic. And if they were, I guess when you're devising a study, there's any which way to look at it. And then how do you differentiate what's a reasonable versus unreasonable claim right out of the gate? Mm-hmm. I get that, but I find this topic to be very interesting. Are there any other allegations that you're seeing about gender bias?
No, so I mean the claims that were made and the reason why I was pushed into doing the research was really the claim that men were not getting a fair shake in these cases. And I think that the research that I've done, as I said, I think it suggests that could be at play in some of the cases that are coming before courts. And this is not to say that the judges themselves are coming in with a gender biased mindset. I think a lot of what's going on here are just very entrenched ideas about how we see the roles of men and women in relationships. And it's hard for us to sort of be thinking outside the box, so to speak, when we're dealing with what seems to be kind of a novel area, right? Which is men making these claims. And I should say, I mean, these are really important, and it's a very important issue to talk about, certainly, but they still represent a pretty small number of total claims. So I compared the claims by men and sort of general, sort of all claims, and it looked as if they were about 5% of the reported decisions. So we're seeing definitely an increase in the number of claims that are being made, but they still represent a very small fraction of total claims. That said, I think that there are reasons to believe that we're going to see more of these cases in the future. So just in the last decade, there's been a real uptick, and I'm sure it has a lot to do with the financial circumstances of families, but also the fact that we're seeing real changes in the labor market in terms of we have a lot of women now in the labor force. We have more women who are acting as breadwinners for their family. We have a lot of men who are stepping up and doing a lot more care of children and housework. So we're seeing things changing in the home, and I think that's inevitably going to result in changes in how people separate and then make claims upon separation. And I think it's just a matter of us making sure that we're catching up to those changes as we bring these cases before courts.
Well, I tend to agree wholeheartedly with your last statement about the changing of the market. I think of my firm. We're 10 lawyers, 2 of us are male, 8 are female.
Right.
That's probably more, maybe overly reflective of what may happen in the future, but there's more of that. And I think as that generation gets older and we see more of that, and that generation has appointments to the bench, these kind of issues may no longer be there. But one thing we didn't touch on, and I want to touch on very quickly before we finish, is where you discussed litigation tactics of intimate partner violence.
Sure.
And one of the things I've always said to my clients when they come in with those allegations is what I don't want to put in materials when we're actually giving our evidence is to say he or she assaulted me throughout the marriage, because very often somebody comes in and just says I was assaulted throughout, and I'll say to them that's a generic statement that anybody can say. Anybody can say I was assaulted. Give me some details of, give me your top 3 worst events. And I don't mean to minimize it, but when somebody says, I remember after this event, this is what happened, and they go into particulars. When a judge hears that story, especially when there's no witnesses, highly probable they didn't go to a doctor afterwards, so you have no independent evidence. You're telling a story. For a story to be believable, it actually needs details attached to it, rather than the generic, I was abused. And in the cases where you say you could see some of it didn't have merit, would I be correct in that kind of assumption that the allegations were very generic?
That's a pretty specific question. And it's hard for me to say off the top of my head what the nature of the allegations were in those cases. The reason why I was assuming that they were meritless is often because of comments made by the judges themselves who had said that they were effectively meritless claims and shouldn't be moving forward. But also the fact that the claimants were not necessarily in a much different financial circumstance than the potential payors. So the men who were claiming did not have significantly less resources than the women, for example. And unfortunately, many of these cases involve self-represented litigants. So your advice to counsel about being very careful about the types of claims that you're bringing to court also applies to those who are representing themselves. And so I think probably there wasn't that speed bump in the road for some of these litigants who were bringing claims without merit to sort of be checked by their lawyer that this was perhaps not the right approach. But again, I think it really does depend on the case, the claimant, and of course the judge that's going to hear the matter.
Okay, well, I see that we're out of time, but I found it a fascinating topic to discuss. So I hope that our viewers have got an idea of what makes male litigants can expect when claiming spousal support, how gender bias or intimate partner violence may or may not play a role in how family lawyers can assist their clients with these materials. And if you're looking for assistance as part of your separation or divorce matter, feel free to contact us. Take a look at our website, separation.ca. There's lots of information available for you. The next Ask Andrew show is on Tuesday, August 28th at 12 noon. If you have any requests or ideas for future shows, please email us at info@feldsteinfamilylaw.com. And to Professor Houston, thank you so much for joining us today. It's much appreciated.
Pleasure.